Hello, my name is Jacqueline Michelle Norris, and this is Module 8 called Legal Aspects of Teacher Evaluation. I'm going to be talking about 5 different things during this slideshow presentation. I have 3 summaries of different articles. I'm going to be talking about teacher evaluations in Nevada, and I'm going to be talking about recourse for teachers in Nevada if they're unhappy with their evaluation, a legal case, and a reflection. Let's get started. Summaries include an NEA article and 2 Education Week articles. The key ideas from the first article, the NEA teacher evaluation, is that the Every Student Succeeds Act has ended the federal government's involvement in prescribing and influencing teacher evaluation systems across the nation. The law permits states to redesign and submit descriptions of their new accountability systems to the U.S. Department of Education. It prohibits the Secretary of Education from prescribing teacher evaluation systems. It requires states to develop their own goals, long and short-term goals. It does not require test scores. States may design and implement evaluation and support systems that are based in part on evidence of student academic achievement. For bargaining, the ESSA provides rights. It does not give you the right to bargain evaluation if you didn't already have that right. The ESSA protects bargaining rights. By reviewing all language and contracts, the association, your local union, may decide new language needs to be negotiated. ESSA guarantees the local education agency to, quote, meaningfully consult all stakeholders as well as community partners to develop a grant application that covers a number of issues, including evaluation. This provision provides the association with an opportunity to provide input regarding evaluation, even in non-bargaining states. And then NEA's evaluation website at the link below contains contract language examples and guiding principles to consider when creating or modifying an evaluation system. So this is the second summary of Education Week called Teacher Evaluation Heads to the Courts. Because of this reform in teacher evaluation policies, there's an abundance of lawsuits at the federal and state level, including lawsuits that involve unions and lawsuits that involve matters such as tenure. The Education Week article then goes on to break down the key ideas of certain lawsuits in certain states and provide updates as to the status of each case. The third summary is again from Education Week called Teacher Evaluation and Issue Overview. Many evaluation systems are have been completely overhauled recently. And in fact, by the end of 2000, teacher evaluations, quote, had become one of the most prominent and contentious topics in K through 12 education. These changes are caused by 4 factors: new research on teacher quality, boosting teacher effectiveness, efforts to revamp state laws on evaluation, and political pressure to dismiss poorly performing teachers. Interest in teacher evaluation systems grew because of several key issues. Analysis of year-to-year student test data consistently showed that some teachers helped their students learn significantly more than did other teachers. People argued that current evaluation systems for teachers were ineffectual and, quote, were perfunctory. Federal intervention gave $4.3 billion in their Race to the Top competition, offering grants to states that agreed to make certain policy changes. The new evaluation systems are far more complex than previously used checklists. The new systems use statistical value-added model, which attempts to filter out sources of bias in the test growth score so as to arrive at an estimate of how much each teacher contributed to student learning. The Department of Education was stating that this kind of evaluation was subject to much random errors. The teachers union felt that there is a potential for improved evaluation systems to provide valuable feedback, but remains cautious about connecting the systems to teacher pay and tenure and draw a hard line at the inclusion of standardized test scores in systems. There's a lot of district pressure to use standardized test scores, and that contributes to anti-testing sentiment and includes the opt-out movement. Are these new strategies working? The process of evaluation is in progress. Some who feel success in new systems of evaluation include people on the cusp of failing or teachers who are close to receiving bonus pay may see an increase of evaluation scores. However, there are many challenges and arguments that the systems are implemented incorrectly, and those who feel they are unfair or even counterproductive. In Nevada, the teacher evaluation process is as follows. In 2011, Nevada established a statewide performance evaluation system for teachers and building level administrators. The evaluation system rates educators as highly effective, minimally effective, or ineffective. Student achievement data from statewide assessments are used to determine educator effectiveness ratings. This system is now known as the Nevada Educator Performance Framework, or NEPF for short. Some of the teacher recourses that we have here in Nevada is basically a grievance. In the grievance, the supervisor is included in an informal discussion, and it's encouraged as the first step in the grievance process. If the matter is not resolved, a teacher must file a grievance within 10 days of that meeting. Upon receiving the grievance, the supervisor will arrange for a meeting and either may request to have a representative also present for the meeting. The supervisor will provide the aggrieved party, the association, with a written answer to the grievance within 5 days. If the grievant is not satisfied with the disposition of his grievance, and if no decision has been rendered within 5 days, the grievance may be referred to the superintendent. The superintendent shall arrange for a hearing with the grievant and the association representative to take place within 5 days. The parties shall have the right to include representation, witnesses, counselors they deem necessary. The superintendent will have 5 days to provide written decision. If the grievance is not settled, the grievant may file a written appeal to the superintendent requesting mediation. The mediator shall confer with the superintendent and the association and hold a hearing promptly. If no solution is reached to the satisfaction of both parties, the grievance may be submitted to the school trustees. The school trustees will answer the grievance. If the grievant and the association are not satisfied with the disposition, may they submit the grievance to arbitration. The arbitrator's decision will be in writing and will be set forth the findings of fact, reasoning, and conclusions on the issue submitted. The arbitration is then final. It was difficult for me to find any current cases of law in the state of Nevada, so I opted to use one that was fairly close to some of the complaints that I had heard here in Nevada. Sherry Lederman filed a lawsuit because she was rated ineffective. She was judged ineffective on a specific portion of her annual evaluation, and this was based on statistical growth model measuring how much her students improved on standardized tests. Though her overall rating was effective, Lederman said that the lower growth score had a demoralizing effect on her, and with the help of her husband, Bruce, a lawyer, she sued the state. Bruce Lederman hailed the decision that the judge made as a victory, and he expects the case to receive national implications. He is quoted as saying, "We know that the system is a failure from our experience, and we hope the decision on a national level brings that home to people." The judge ultimately vacated Sherry Lederman's test score rating. Bruce Lederman said that in his view, the true harm of test-based evaluations is not direct dismissal of teachers, but the broader systematic demoralization of educators. The system is insulting and dispiriting to teachers, he was quoted as saying. Sherry was in days of turning in her resignation because of this experience. The State Teachers Union, which is not directly involved in the case, praised the decision in a statement. Quote, "New York teachers statewide have been unfairly labeled by the state's untrustworthy and mysterious mathematical algorithm that took the focus away from what matters most, teaching and learning." The judge himself criticized the fact that this approach to evaluations created a bell curve, ensuring that some teachers will be marked below average regardless of overall results. Upon reflection, these 3 articles, the teacher evaluation process in Nevada, the recourses that teachers have, and an example of a lawsuit, I came to realize that I could write pages upon pages of reflection of how I would plan to make sure my teachers were happy. but I focused on 3 things. The first was to set an example. As a building administrator, I'll set an example of promoting trust, good manners, being fair, and these mutual pathways of respect. I will also try and keep very current about new laws and policies regarding evaluations, and I'll also promote awareness within my staff so that if there are any modifications or changes, we will know and be able to implement these changes together. 3, something that's very important to me is to be able to adapt. Being set in your ways is never a good idea, so I would definitely hold myself to a challenge of adapting leadership strategies and to address any emerging educational issues on the district, state, or federal levels. Thank you very kindly for listening. I also wanted to thank a few of my teachers: Victoria Skinner, 5th grade English, who inspired me to be a teacher; Liliana Isfan, my art teacher from kindergarten through 12th grade; Robert Petrovich, my principal and history teacher, grades 9 through 12; Barbara Snyder, my kindergarten teacher and the lady who taught me to read; Robert Buchanan, my music teacher, mentor from 6th through 12th grade; and lastly but not leastly, Jacqueline Lord, my very first teacher, my mother. Thank you.